Mr. Wagner is here today after failing to appear before referee Coleman on March 15th, 2024. Bond is currently set at $1,499. This is the second bench warrant. He reports that he is employed at Prairie Farms. Last payment made on this account was in March of 2023. Front of the court recommends that a reasonable bond be set in this matter and it be scheduled for hearing on June 12th, 2024 at 8:45 a.m. before this court.
Mr. Wagner, you're before the court charged with civil contempt of court due to your failure to appear at a prior proceeding as a result of your failure to pay child support. Purpose of this hearing is to set a bond that would assure your tenants at the next hearing on June 12, 2024 at 8:45 a.m. You will get notice of that in writing. Are you able to post a bond, sir?
I am not. Actually, I just started Prairie Farms last Tuesday. I'm actually supposed to work tonight. I have every intention on making a payment as soon as I receive my first paycheck. I was unaware of the court date until after I'd already missed it for the failure to appear.
Okay. Well, you should have come into court after that date, even though you missed it. We could have done something rather than having to put you up on a bench warrant, and that would have been much better than having done nothing.
Yes, absolutely, Your Honor.
Well, you have a sizable arrearage and you haven't paid in well over a year. What the court's going to do, I'm going to set your bond in the amount of $500. If you're able to post that, you'd be able to be released. Do you have any questions?
No.
Okay. Thank you, sir. You're free to go.
DS. In each of these matters, Mr. Becerra is here today after failing to appear before this court on August 2nd, 2023. In the first case, bond is currently set at $743. This is the fifth bench warrant. In the second case, bond is currently $728, and this is the third bench warrant. He reports that he is employed at Fiber Specialists, LLC. Last payment made on these accounts was in August of 2023. Front of the court recommends that reasonable bonds be set in these matters and they be scheduled for hearing on June 12th, 2024 at 8:45 a.m. before this court.
Thank you. Mr. Becerra, you're before the court charged with civil contempt of court due to your failure to appear at a prior hearing as a result of your failure to pay child support. Purpose of this hearing is to set a bond that would assure your tenants at the next hearing on June 12, 2024 at 8:45 a.m. You will get notice of that in writing. Are you able to post a bond, sir?
I am not. Not at the moment.
Okay.
Only way I'd be able to pay anything is if I were to get out, and I'd be able to pay next week. I'd pay maybe the $1,200. But other than that, if I'm not at work this week, I lose it.
Okay.
And I just got myself to $30 an hour. So I mean, if I can't make it to work, I go back down to like $10 an hour.
Yeah. Well, that's unfortunate, but you basically should have done something before this. Could have started paying. You could have done all sorts of things that would have kept you from being picked up, but you apparently didn't do that.
Well, I mean, it's not that I didn't want to pay. I mean, for the first part, I mean, I'm always at work. I work all over the place.
Well, so you're working. How long have you been working at Fiber Specialists?
Like two and a half years.
And during that 2.5 years, you couldn't do anything to make payments since last August.
No, I have been, but the thing is I've called down to the court. They gave me how much to pay. I've always called when I talked to them. They gave me the price that I had to pay to get rid of the warrants and stuff, and I've always called down there and pay them, and my warrants were cleared. Except for this last time, I had no money to be able to do that. I mean, I got other kids I'm trying to take care of too, so I just did not have the money at the time.
Well, you had money at some point, obviously from August to current.
Now $400
working and you've been making
roll out there for it.
You've been making good money during that time, so you had some time.
No.
Well, what I'm going to do is
I haven't really worked anything since December. Like I've worked maybe 4 or 5 weeks this whole year.
Okay.
And I'm just now starting to get back to work, and then now I'm in here. So
okay.
Like I have no money.
Well, what I'm going to do is I'm going to reduce your bond in hopes that you'd be able to be released. I'm going to set your bond in each case in the amount of $300. If you're able to post that, you'd be able to be released. Do you have any questions?
I do not.
Okay, thank you, sir. You're free to go. Have a good day.
For it, 9:07 a.m.
Court will note the appearance of Mr. Schaefer on behalf of plaintiff, Ms. Cheltenham on behalf of the defendant. This matter is before the court on the plaintiff's motion to place the child in the care of, again, the legal father, Mr. Schaefer.
If it pleases the court, Your Honor, this matter came about because of concerns of my client in relation to his wife and her mental state and mental illness, and the concern for the 9-month-old child. She had been hitting herself on the wrists and the abdomen. She had made accusations of self-harm. She had taken the child, and the child was not being made available to him. As a result, that's the reason for this petition. The petition is for temporary custody to set supervised parenting time for exclusive use of the marital home, and request for a psychological evaluation of the defendant wife. Your Honor, since this has been filed, the parties have had communication with each other. The current status, as I understand it, is that they have made arrangements between them that my client is having the child with him every weekend, Friday until Sunday at noon, that he has the child with him 2 days during the week. So that it is, there's been some talk going on. I think that ultimately that is good. Ultimately, it's in the best interest of the child that the parents are talking. We are asking that on a temporary basis that there be a week on, week off, with each parent having one overnight on a Wednesday in the off week, so that there is not a long period of time that either one will be away from the child. So we are asking that on a temporary basis. I think there's going to be a need for an evidentiary hearing in that regard. In the meantime, the defendant wife has extricated herself from the home, is living with her parents. So I think the exclusive use request of the marital home is appropriate, so that he can feel secure in that living quarters, that he is making the payments on the home at this parent time. And we're asking that there be a psychological evaluation set. The answer to this particular matter has minimized a lot of things which I don't think is appropriate. Anybody who is themselves has a mental disorder in that regard, and whether or not she is intending to kill herself or not is concerning for that parent having control on a regular basis that is unsupervised for a 9-month-old child. And that is absolutely the reason for the filing of this petition. In quick response to the answer and the counter motion for attorney fees, we are submitting that there was great factual and legal reasons for filing this complaint of concern for the minor child, and that the requests for attorney fees are not warranted in fact or law. But I think on a temporary basis, I would respectfully ask to be a shared custodial situation, that currently the child is being supervised in the maternal parent's home. That's where she is living at the present time. That be week on, week off until we have an evidentiary hearing or try to come to some resolution in this particular matter. So that's our request at this time, Your Honor. Thank you.
Okay, thank you. Ms. Cheltenham, what's your response?
Well, first, we'd like to sort of address the allegations against my defendant. We have 3 main allegations. One is the allegation that she has mental health issues, which causes her to harm herself. And then on top of that, there's a presumption that there's some sort of suicidal ideation that was sort of underlying in plaintiff's original motion. The next allegation is that she's got some sort of alcohol use disorder that places the child in danger while in my client's care. And according to an email I received on May 21, 2024 from plaintiff's prior counsel, there's an allegation that defendant was imposing her eating disorder on the minor child, and the minor child was not eating properly and was underweight. I know that wasn't in the motion, but the problem with all of these allegations, Your Honor, is that they're just simply, in essence, untrue. It's not untrue that my client, she doesn't deny that she did harm herself on May 4th, 2024. She doesn't deny that she drank alcohol on May 4th, 2024. The self-harm was an incident that occurred after a year and a half, almost 2 years, where she had stopped that behavior. She had some anxiety and depression she was suffering under when she was younger, Your Honor. I know it's only a year and a half ago, but my client is young still. She pulled herself out of that situation. It was a situational issue for her at that time. On 5/4, when she performed the act of self-harm, one, it wasn't her risk. Plaintiff keeps saying it was a risk. We have the medical record from the assessment that my client went under after plaintiff petitioned the probate court, demanded that she be evaluated for mental health evaluation on an ex parte basis, which she did. She was calm. She was cooperative. She was escorted by the Michigan State Police. She was assessed, and she was assessed by a professional. And in that record, it indicates that Ms. Deschaney is not a harm to herself or others. She was not suicidal or homicidal. That the abrasions that, and that was a term used by the medical professional, Your Honor, that was on her forearm, not her wrist, and her abdomen, were superficial. And in fact, in plaintiff's petition to the probate court, he even admits that they were superficial, but then inflames the issue in later language and through his filing later. Defendant wasn't hospitalized by the assessor, and they refused to hospitalize her. They let her go home. They're not concerned. And in fact, the police officer placed the child back in my client's care after she was returned home. So nobody was in fear for the child at that time. And this is immediately after there was this self-harm incident that my client unfortunately engaged in. And Your Honor, and we outlined this in our response, and I'm not going to go through all the dirty details, but basically that was a response to plaintiff and an argument between plaintiff and defendant. The marriage is falling apart. She's just had this baby. Plaintiff is basically stonewalling her, ignoring her pleas for him to return home from a party that he was at where he was drinking and smoking marijuana, and I think he fails to disclose that to the court. My client admits that she was drinking at that party. She did drink to excess. She admits that. You know, there's allegations that she drove after that. She admits that she drove a four-wheeler on private property after that incident. The incident of 5/4 is a one-off incident after a year and a half of not having these issues. She had a situation where she spiraled emotionally. She reacted to get plaintiff's attention. It's unfortunate. It occurred. She's no longer in that situation. The parties are separated. And we have a professional saying she's not a harm to herself or others, and releasing a police officer released the child back to my clients. We think all of those things are important. As far as assessing my client is concerned in relationship to her quote unquote mental health disorder or mental health illness, one is she was already assessed pursuant to plaintiff's petition. We don't see why that she would need to be assessed again, but she's willing to do that. If the court is going to order her to be assessed, then we ask that she be assessed by Dr. Brooke Van Burenhay, who is a licensed clinical psychologist. She is mainly in the Ingham County area, but she does practice in surrounding areas. She is an excellent psychologist. She has been an expert in a number of cases, including a case of mine that I have used her on. Of course, my relationship with her is strictly professional. I trust her. She is also an attorney, so she makes an excellent witness. She would absolutely produce a non-biased report. So if the assessment is required, then we ask that she assess my client. There was, I believe there was a request in the motion anyway for alcohol and drug assessment of my client. My client doesn't have an issue with that. She doesn't have an alcohol problem. She never had an alcohol problem. And in fact, it is our position that plaintiff is the one with the issue with drugs and alcohol. He does drink to excess, not that he's not an adult. They're both adults. They can drink to excess. He smokes marijuana. That's completely legal. What my client's concern is that he has boasted about smoking marijuana and then driving, quote unquote, more times than he can count. And that's an issue for my client as far as his parenting time is concerned. He has a right to smoke. He just doesn't have a right to get in his car, just like alcohol. You can't get in the car and drive. He did that, as a matter of fact, on 5/4. So we want to go back to that. He was smoking marijuana. He was drinking and he drove, but he didn't disclose that to the court. Instead, he throws my client under the bus and tells the court that she's got a mental health disorder and that she's a drunk, which is not true. In any event, my client's willing to be assessed for alcohol and drugs. Neither one are an issue for her. If that's going to be ordered by the court, then we ask also that plaintiff be assessed for alcohol and drugs. That is done by a hair follicle test. My client's willing to go through a full assessment. or inclusive in a hair follicle test and an assessment is what I guess is what I'm saying, Your Honor. She's willing to do both of those things. We ask that if she's going to be assessed, we have Kimberly Podmore assess her. She's another expert that I'm just familiar with that does drug and alcohol testing. She's known for that in the Ingham County, Eaton County, Clinton County, and Shiawassee County areas. And she certainly has testified before as an expert. So that would be something that we would be willing to do, more than willing to do. As far as the remaining issue, the eating disorder. The eating disorder was, again, an issue for my client and situational at the time. It's been over 1.5 years since she's engaged in that behavior. She had a healthy pregnancy. She had a healthy baby. The baby is healthy. And as far as any implication that she would misuse that prior issue of hers on the child, which has been implicated by defendant's counsel, or plaintiff's counsel rather. And in addition, plaintiff took the child to the doctors, my understanding recently, to have the child checked over to see if there was a health issue because of the eating, quote unquote, restrictions that my client has on the child. We have the medical record of the child. I forwarded that medical record to opposing counsel yesterday when I received it, as soon as I got it in the afternoon. And the medical record indicates very clear that the child is healthy. There's nothing wrong with the child at all, as far as any sort of, and there are no concerns with the child's health. She's progressing just fine. And I've seen pictures of the child. She's beautiful and she looks like a happy, healthy baby. So we find that those things are at minimum inflamed. I mean, surely my client is concerned about the child's feeding habits, but not to the extent that she's harming the child. And we think the evidence is pretty clear that there's no mental health issue that would prevent my client from parenting, that there's no drug or alcohol issue that would prevent my client from parenting. Also, Your Honor, that the alcohol and the eating disorder were considered by the evaluator that assessed her for her mental health, quote unquote, issues. They found essentially nothing wrong with my client. We don't think that it's warranted that she be under supervised parenting time. And clearly, plaintiff is offering an equalized parenting time, so he's not concerned for the child's care. We think that's important for the court to consider. And in fact, the parties have been under a schedule. It's not equal. My client has her own concerns about plaintiff. One is the alcohol and drug use while driving or while the child is in his care. 2 is the fact that plaintiff has this inability to wake up in the middle of the night that she doesn't quite understand, but that's been prominent through their relationship and through the short life of this young child. We would like that issue assessed because it really is a problem where my client's concerned there might be an emergency. The child may need dad in the middle of the night and dad cannot wake up. We would like to have that issue assessed so we can use it for an evidentiary hearing later. And if it comes out great, then it's not a real issue, I guess, but that's a concern. In addition, my client has been the primary caretaker of this young child since she was born. Again, she's only 9 months old. And then at 9 months, my client's been responsible for not only working, because she was working, and then responsible for the child's maintenance and daily care, including meals, pediatric appointments, taking care of bedtime routines, bath time, changing diapers. Not that dad didn't sometimes engage, but even when asked, frequently dad would refuse or decline to engage in things like bath time and some of those other daily care routines. Plaintiff is clearly not concerned about the child in my client's care. What we're asking for the court to do is place the client in my client's as a primary custodian and having dad have every other weekend. Right now he's got every weekend and my client's been very accommodating with my counsel to her. But with her going back to work and she does have a new job, she's requesting that dad be under every other weekend with extended parenting time during the week like they have been doing. So there's 2 times a week dad has physical contact with the child. And I'm looking for that schedule right now. For some reason it's escaping my notes. But from what I remember, something like Mondays and Wednesdays, dad has contact with the child from 4 to 8 p.m. My client's happy to continue that. In addition, she does FaceTime with dad. And that is on the Tuesdays and Thursdays, I believe there's FaceTime that dad has with the child at bedtime. And then really my client doesn't want dad to have the overnights. And if he does have the overnights, he should be staying with his mom, which is I believe that he's doing right now. So my clients felt safe during these overnights because of plaintiff staying with his mother and his mother at least being someone present who can wake up with the child, because that is a real significant concern for my client. As far as the attorney's fees are concerned, we think the attorney's fees are appropriate, and the attorney's fees are appropriate. It's because of the overly litigious nature of this. My client withheld the child, if you want to call it withholding, for approximately 7 days. This is immediately after my client had to endure plaintiff trying to secret the child away from my client. So she was very suspicious that plaintiff was going to try to remove the client from her care permanently. She was trying to figure things out. As soon as she hired counsel, she listened to me. She did what she was supposed to do. She allowed the parenting time. Attorneys were working together. She wasn't trying to permanently deprive dad of anything. And she did work with him on her own. So we don't think that 7 days was enough to say that she was withholding the child. But in any event, the attorney's fees, as far as the overly litigious nature of this, is that the motion wasn't really necessary, first of all. Secondly, not that dad doesn't have a right to file it, but he placed a lot of information in that motion that was either twisted facts or false information. And we think that was done to inflame the situation for my client. It's clear by the whole process of this, of her having to be evaluated on an ex parte order, which was completely unnecessary. Then the facts come into the court that, she essentially that my client can't have parenting time, but then he says equal is okay. It's his litigious nature that we're concerned with. We didn't have to be here. We could have stipulated to something. They are stipulating to something. And so we've wasted, I would say wasted over $3,000 defending this matter. And I'm continuing to work with my client and, in preparation for an evidentiary hearing, of course, that we have to do. But because of those things, we think the attorney's fees are appropriate in this case. We're asking ultimately that the court deny plaintiff's motion as it is outlined and requested. We do think that parenting time is important for both parties. We're asking the court to adopt our request for parenting time, to order the attorney's fees, and if the court is inclined to order evaluations, make that a mutual evaluation of both parties. We're requesting that the evaluations be conducted by the evaluators that we recommend, Your Honor. Thank you.
Do you have any issue on response on the exclusive use that they've requested?
Oh, I apologize, Your Honor. I missed that. So as far as the exclusive use and possession are concerned, we don't think it's really necessary. My client hasn't been trying to get into the home. She's not trying to, she's not berating plaintiff. He's able to live free in the home. We just don't think that it's necessary. I don't know that it harms anybody to have exclusive use and possession. But again, we think that was more of a frivolous filing and not necessary. But I do know, well, I'll leave it at that. So as far as exclusive use and possession is concerned, we just think it's not necessary at this time. My client has property there she'd like to have access to. She doesn't have room to move it into her parents' house right now. So she should be able to go in and out freely is what we believe. And if he has exclusive use and possession, obviously he can prevent her from doing that. Thank you.
Thank you. Mr. Schaefer, do you have any problem with mutual, psychological evaluations?
No problem with that, Your Honor.
Okay. What the court will do is the court will grant.
Your Honor, may I respond to some of the
I don't think it's necessary at this point. Court will grant the plaintiff exclusive use of the residence. They're saying that there's no need for it, but then they're arguing against it, and that does cause some concern in this matter. The court will argue that the parties would engage in each have a psychological evaluation, that in fact I'll leave it up to the parties as to who they want to have do that. And if you have each have a different psychologist do it, then so be it. But we'll have each of the parties get their own psychological, exchange those with the other side, and provide the reports to the court as well. The court would, I do believe, based upon the statements, they're stating that there was by defense counsel that there's no need for anything. She wasn't doing any, that the injuries that she had were superficial, and yet she does acknowledge that it was self-harm, that she had drank to excess, and that she also then drove at that particular time. That does cause some concerns in this particular matter. The court does note that the parties separated back on May 10th, 2024, based upon the pleadings in this case. The court does believe that it is appropriate in this matter to maintain the status quo. The court is going to order that the parties would each have a joint physical custody of the child in this matter on an alternating weekly basis, with a Wednesday overnight by the other party from 4:00 p.m. until 8:00 p.m. on Thursday morning. The court would order that neither of the parties would drink or consume any marijuana during the time the child is in their respective care. The court would also order that the plaintiff would invest in a baby monitor, so that when the child's with him, he has the opportunity to hear the child if in fact that is a problem. and that he would again acquire that prior to having the child with him. And the court would also deny the request for attorney fees. Contrary to what defense counsel says, I think there was ample reason that this matter was brought before the court. And obviously the parties haven't been able to agree today on much of anything. So obviously there was a need for the motion. So the court will deny that particular request. I will ask Mr. Schaefer that you would prepare that order submitted under 7-day, and the court would start his custody, his overnight this Wednesday, which would be June 5th, and that his week would start on June 7th, 2024, and then alternating weeks thereafter. The court would then, I know we have some holidays coming up, it would alternate the holidays as well. Mr. Schaefer, are you able to prepare that order?
I will, Your Honor. Thank you.
Okay, thank you. That will conclude the matter. You're free to go. Have a good day.
Your Honor, can I ask one more question before we leave? As far as, taking into consideration the child's age, and I understand the court imposed an overnight on Wednesdays on the off weeks. We were wondering if we could do more of a shortened visit between the parties, so there's frequent transfers. The child's only 9 months old, so my client is wanting to see if we could have more of a 2-3-3-2, or
What I'll do is allow you, the attorneys, to speak and see if you can come up with some arrangement. If not, you have my ruling.
thank you.
Thank you. Court will note the appearance of Mr. Todd on behalf of plaintiff, Mr. Fisher on behalf of the defendant. This matter is before the court on defendant's motion to set aside default. Mr. Fisher.
Thank you, Your Honor. This motion is based on 3 different reasons to set aside default. One is the defective improper service on defendant, good cause, and manifest injustice if the default is not set aside. Regarding the improper service, the defendant could have been served by personal mail or served by registered mail or alternative service. Service cannot be done by e-filing since e-filing is not mandated in our circuit court. Therefore, my client's receipt of an email does not constitute service. Had the parties agreed to alternative electronic service, the email would have constituted service had the parties filed a stipulation in this case, which is allowed by MCR 2.107C4A, which they did not file.
Okay, let me interrupt, Mr. Fisher, and only ask Mr. Todd. Mr. Todd got an improper service through e-filing. Want to respond?
Yep, absolutely. That was not in the initial motion itself, so we would respectfully request that be stricken. But beyond that, we didn't actually file that based off of electronic service. We filed it based off of an acceptance of service. He is required to sign documentation stating that he received it, which he did do, and that is what's on file with the court. His actual signature verifying that he received it. So it's not electronic service. It's just akin to acceptance of service, which he agreed to do and which he did.
Mr. Fisher, how do you respond to that?
Yeah, I'd respond that the email that Mr. Todd sent to the defendant stated right on it that his acceptance is not indicating you agree to anything, just that you received the documents. So
Okay.
he thought he was acknowledging, based upon the wording of Mr. Todd, that he received the email, he received the documents, not that he was accepting service.
Well, I guess I don't read it that way. I think when he says, again, that he accepted service in that particular matter, that again, service was proper through acceptance. So go ahead, Mr. Fisher.
Okay. Secondly, I would submit that defendant has good cause to set aside this default. It was entered within 48 hours of the 21 days running on the summons, and it was received by a link with the summons and complaint and other initiating documents attached. The Michigan Supreme Court has defined good cause in the Elkin Ziegler case as a reasonable excuse for failure to comply with the requirement that created the default. The reasonable excuses that defendant has to set aside are the follows. First, sometime prior to the entry of this default, the parties were amicably working together to resolve all matters. The plaintiff got an attorney to help them facilitate filing and getting the divorce. They felt they could resolve all matters relating to the dissolution of the marriage. In fact, the parties resolved physical custody, where they have joint physical custody alternating weeks. They resolved the issue of joint legal custody, and they resolved the division of almost all of the household contents. Plaintiff's counsel and both parties believed they could resolve the matter without having the court involvement. And based upon these representations, the defendant didn't retain counsel. Notwithstanding that Attorney Todd was aware that they had resolved a number of things, almost all, he, without any notice to the defendant, immediately issued a default. He could have just sent an email or telephone call to defendant saying, I know you're resolving things, but I need an answer filed. Get it resolved or file an answer within 5 days or a default would be entered. There was no courtesy of that whatsoever. They say that contrary to their answer saying, well, now that the default was entered, the defendant won't talk to plaintiffs, so they can't resolve anything. That is absolutely not true. They cannot talk or resolve anything because the plaintiff is furious that he got an attorney in this matter and filed a motion to set aside the default. I believe that there was a game being played here. Act like you're agreeing to everything so we could get a default entered. And the second good cause is the defendant, in signing the acknowledgement of receipt of the documents, he believed in his mind that in lieu of filing an answer, he was taking other lawful action with the court. That's what he thought that meant, not that he couldn't do anything or a default would be filed against him. In regards to the manifest injustice that could result if the default is not set aside, in the link that Attorney Todd sent, he sent all the initiating documents except for one important document that must be served upon the defendant, and that is the verified statement. A copy was not sent to the defendant, and as of this date, a copy was not sent to this defendant. Had that verified statement been sent to the defendant, then he would know income for purposes of child support. He would know whether or not he has a good claim for child support. He would know whether he had a good claim for spousal support. With that not being filed, he does not know. The second manifest reason would be in paragraph 12 of plaintiff's complaint for divorce. He alleged that during this in excess of 10-year marriage, the parties did not acquire any property and did not acquire any debts. This is absolutely false. Almost all the personal property the parties had were acquired during the marriage. The parties have a marital interest in a real estate that has a value of approximately $200,000. And the defendant believes that they also have marital interest in deferred comp plans. Your Honor, I believe that the default should be set aside so the court will have the benefit of the parties' positions as to all matters to make a fair and equitable decision. In this case, there's absolutely no evidence that the defendant intended to delay adjudication of this matter. He immediately took a response within a default that was entered with less than 48 hours of the 21 days running. And there'd be absolutely no prejudice to the defendant by the default being set aside. Thank you, Your Honor.
Okay, thank you. Mr. Todd, your response.
Yes, Your Honor. Your Honor, it's not my job to inform the defendant of what he should or shouldn't do. My client did inform me that they were working together, and I believe that they could continue to work together. It's odd that the default itself is what is allegedly preventing the defendant from speaking with my client to resolve this. I mean, that allegation is very much a catch-22, in essence saying that we agreed to everything and we'll be able to resolve it amicably, but we want the default lifted in order to speak with you to resolve this amicably. Unfortunately, that just simply makes no sense. The allegation of improper service is not accurate, and the statement that the verified statement is not. And I'm happy to send that out to Mr. Caldwell. But regardless, either way, the fact remains that he did not file an answer. He had a full right and opportunity to file an answer. He had a full right and opportunity to not accept service. He had a full right and opportunity to seek independent counsel, which apparently he did not do. So there is no reason why that default should be set aside at this point. In relation to the complaint, his opportunity to state that there are improper statements within the complaint are through his answer, which he didn't file. And the statements within the complaint are in essence because my client has premarital property, which was acquired before the divorce. And so we believe that there is no marital interest. However, we do believe from a pragmatic standpoint, it would make sense to allow the parties to continue to participate in mediation, but have the default remain in place.
Okay, thank you. Well, in this matter, the court has read all the pleadings and heard the argument in this case. The court, as stated previously, believes that when he signed and accepted that, he did accept service. And that's one of the arguments by Mr. Fisher that, well, he signed something in lieu of answering. Well, there's nothing in the summons to say, well, you can sign something in lieu of filing an answer in this matter. As far as good cause, it said they were working together. That's great that they're working together, but that's not a basis. And that doesn't, in fact, amount to good cause to set aside a default. And as argued that Mr. Todd didn't provide him with notice he was going to default, there's no requirement that, again, a party provide notice to the other one, we're going to default you if you don't respond. Court doesn't believe that there's been a showing of good cause to set aside the default. The court's not going to set aside the default, but I do believe that there are some issues in dispute, so the court is going to allow the defendant to be involved in disputed matters, and the court will order that the matter would proceed to mediation in July. Mr. Todd, who would you like as a mediator in this matter?
John Brundage, Your Honor.
Mr. Fisher, do you have any problem with Mr. Brundage?
I have no problem with Mr. Brundage, Your Honor, but if you're setting in July, are you not allowing the defendant to participate in discovery, which
No, I'll allow you to. What I was going to do is we haven't had a scheduling conference. I want to get mediation going. What I'll do is I'll set up a scheduling conference probably in a couple of weeks, and then we'll get all those other dates in place.
Your Honor, I sent to the court and Attorney Todd a proposed order. One was granting the motion, which obviously you won't use, but I also sent one that denies the motion but allows the participation of the defendant pursuant to the court rule.
Okay, thank
Is
you.
there any problem with that order that I presented to the court?
Yeah, I'll have Mr. Todd prepare one that provides for that, but also provides for mediation in July.
Okay.
So that we have it just in one order. Okay, ask that you prepare that, submit under 7 days, Mr. Todd.
Absolutely, Your Honor.
Thank you. You're free to go.
Thank you.
Have a good day.
45 a.m.
Court will note the appearance of Ms. Zalesnik on behalf of the defendant. This matter is before the court on the defendant's motion to modify custody, parenting time, and support. Ms. Zalesnik.
Yes, good morning, Your Honor. Mr. Lane is filing his motion for the court to review the current custody and parenting time arrangement. That custody and parenting time arrangement is set forth in the judgment of filiation or consent judgment that awards the plaintiff sole legal, sole physical custody and no specific parenting time for Mr. Lane. That order is extremely old, Your Honor. The children are now 14 and 16, I believe. And if I misspoke, I would appreciate the parties correcting me. But right at the current time, the daughter stays primarily with mom. The son, but she is very actively involved in extracurricular activities that Mr. Lane is involved in. He's primarily involved in the extracurricular activities for both children. Getting them to and from activities, signing them up, ensuring their participation and attending, while the plaintiff is not. She's completely absent from those activities. And so Mr. Lane is asking for joint legal and joint physical custody. He's asking for a specific parenting time. He's asking to have the son primarily, and the daughter, she's of an age right now that he'd like to give her the opportunity to choose where she would like to stay, just to not interfere with her everyday life. But this son has expressed, as would be evidenced if the front of the court would interview him, that he would like to live primarily with dad.
Okay. Thank you. Ms. Gibson, what's your response?
That none of that is true, Your Honor. I participate in taking them to and from.
Okay,
As far as
aside
Layla
from that, is the son in the defendant's custody?
Not at all, sir. No, he stays at my home. Mr. Lane doesn't have a home for him to stay in. No.
Okay. Well, in this case, Mr. Lane has stated that he does not dispute the custody of the daughter to be with the plaintiff, so the court will find that there's no proper cause or change in circumstances for an evidentiary hearing concerning the daughter. However, the court does believe that based upon the allegations and the disputes in this case, that there is a proper cause, change of circumstances as it relates to the custody of the son. The court will refer the issue of the custody of the son, as well as parenting time and support, to the referee for an evidentiary hearing. Anything else, Ms. Lesnick?
Yes, there is a current order that was entered with regard to child support. And that was the aha moment for my client, that Ms. Gibson stated that he has no overnights with the son or the daughter, which is not the case. But he doesn't, like I said, he doesn't want to dispute the daughter. She's of an age that he wants to give her freedom to choose. But there is a child support order currently that's in place that he missed the objection deadline. He received notice of that quite after the review and all that, but we would like to hold that in abeyance if possible.
I'm not going to hold up the order. He didn't object. The order will remain in place until it's modified.
Okay. Thank you,
Okay.
Your Honor. And then do I contact the front of the court, or will they contact me to get a hearing?
The front of the court will contact you. We'll do a referral order to them in this matter. So that will be the order. You're free to go. Have a good day.
Thank you, Your Honor. Have a good day.
Judge, would you like her to prepare an order denying the motion?
No, that's fine.
Okay. No, nothing needs to be prepared on my part, Judge.
Excuse me?
Nothing needs to be prepared on my part.
No, we'll do the referral order.
Okay. Thank you. Have a nice day.
Make sure we do that. Just
Yep.
it's custody, parenting time, support as it relates to the
At
son.
9:52 a.m.
Court will note the appearance of Ms. Thomas on behalf of the defendant. This matter is before the court on the defendant's motion to modify custody, parenting time, and support. Ms. Thomas.
Thank you, Your Honor. As we set forth in our motion, it was actually at Ms. Smith's request that the party's minor child is residing with his dad. I think that the motion sets it forth in great detail. And again, because it was originally mom's choice because of some issues with giving him his medication is why it started. I think that it's appropriate to have the order matched what the parties have been doing since December. He's not spent the night at mom's house since Christmas. And so we're asking for the defendant to have primary physical custody with the parties, again, still sharing joint legal custody, parenting time at all times and places which the parties can agree. And then either have the parties exchange pay stubs if that's appropriate to the court, or else impute Ms. Miller. I don't have any idea where she works, so I would need to know that information if we're going to exchange pay stubs.
Okay. I'll ask Ms. Smith in this matter are you disputing custody?
No.
Okay, so at this point, so the defendant, you acknowledge the defendant can retain custody of the child.
I'd like it to be the same agreement we had in the past, just switched. I'd still like to see him.
Well, Ms. Thomas is stating that you would do that, and that the parenting time would be at all times and places you can agree. If you can't agree, then it would be alternating weekends, Friday at 4 to Sunday at 1, and Tuesday and Thursday for 4 hours. And obviously we'd do alternating holidays, et cetera. Is that acceptable to you?
Yes.
Okay. What I'll do is, Ms. Smith, I'll have you and Mr. Woods each will exchange paycheck stubs, which would show your most recent paycheck stub showing what a year-to-date income is. You'd provide that to Ms. Thomas. She would provide it to you. And then Ms. Thomas would be able to calculate the child support amount, and she'll provide you with that calculation and that particular order as well. Okay?
Okay.
And if you would provide that to her, would you be able to provide that to her before the end of the week?
I have it right now. I don't get actual pay stubs. It's just
Okay.
a computer printout.
Well, if you got a computer printout, provide that to Ms. Thomas so that she can calculate the support. She'll still be able to get the order in within 7 days.
Okay.
Okay?
The only other thing I need, Judge, is to make sure what her start date at that job is. Just if it started this year would be a problem if I didn't
Okay.
know more.
Ma'am, when did you start that employment?
It's a seasonal employment, and this year I started on April 18th.
Okay.
Okay.
You didn't have any employment before that?
I'm a stay-at-home mom.
Okay. My question was, you didn't have employment before that?
No, not in a few years.
Okay. Okay, Ms. Thomas, are you able to do it from that?
I can, as long as, yeah, if there's something different or odd about it, I will let the court know, of course.
Okay. Okay, thank you, Ms. Thomas. You can submit it, and then you're free to go. Have a good day.
Thank you.
9:57 a.m.
Court will note the appearance of Ms. Sachs on behalf of the plaintiff. This matter is before the court on the plaintiff's motion for default, stating that the defendant has failed to exchange the verified financial information. Mr. Matthew, why have you not filed that and provided that document?
I did send in my financial information, and then also did a response or something like that. I wasn't sure exactly what. I did get a packet of paperwork from Miss Sachs, and it was asking a bunch of questions like my social media usernames and dating sites and stuff like that, which, you know, I felt had nothing to do with my financials or anything. So I wasn't really sure what to do. I reached out to all the creditors and stuff that I could think of to get our debt information and all of that. And I was waiting to hear back from them. Finally, there was a few of them I didn't hear from. So I just pulled my own credit report, and it has a bunch of the stuff on there. And I sent that to Miss Sachs as well. I do have, it's in my phone, but I have the tracking number and everything for that.
Okay.
Your Honor, this was sent to the wrong legal services office after the date at which I filed this motion. I would also note that what Mr. Matthew is referencing is he has also failed to respond to any interrogatories or other discovery requests, which are now officially late. They were not at the time of the filing. But I can, of course, file a motion to compel on those. What Mr. Matthew thinks is relevant to a divorce case and what is actually needed is different. We are running into the same issue yet again, Your Honor, of him not meeting the deadlines and me needing to file motion after motion just to try and move this case forward. At this point, I can have a default judgment of divorce into this court by the end of the week. And so therefore we're asking that this court follow the normal procedures and default this particular.
Okay. Well, normal procedure, the court pursuant to MCL 552.22, the court can require the disclosure of those. And in fact, they are required to provide those verified financial statements. So, sir, I know you say you provided some of that documentation at different times, but you're providing some of it doesn't mean that you filed the appropriate form disclosing everything that you have to file. I don't know what you filed or what you didn't file, but in this particular matter, court's not going to default you, Mr. Matthew, because you did file an answer to the complaint in this matter, but there are other things that you have to file besides that. One is that verified financial statement, and it has to be on that particular form, so he has everything filled out. If there is other discovery requests, you have to either respond to that discovery request or object to that discovery request. You just can't choose to not respond if you don't feel like responding. You have to properly and submit a proper legal objection to that particular document. Ms. Sachs, what are your attorney fees for the motion in this matter?
Your Honor, it would be $200 per hour for 2 hours of time, coming to $400.
The court will grant to the plaintiff attorney fees in the amount of $400 necessitated by this motion, in order that would be paid within 45 days of today's date. And Ms. Sachs, you can prepare that and prepare an order as well. In the order, just put that the court had denied your request for default, and then Mr. Matthew, file all the appropriate documents, because again, if you don't, then Ms. Sachs is gonna bring you back in on a motion to compel, okay?
Your Honor, at this point, he is already late.
Okay.
What date would you like those documents into the correct legal services office by?
Okay, Mr. Matthew, I'm gonna give you 10 days to respond and provide that to Ms. Sachs' office, which would be the office that she has on the pleadings in this particular matter. And do that within 10 days, or she'll have a right to file her motion to compel. Okay?
Okay, so it all goes to the new address that's on the paperwork, not the one that I've been sending everything else to.
Correct.
So to clarify, that is the 3490, was it Bell Chase Way?
Correct.
Okay.
Okay, thank you. You're free to go. Have a good day.
Thank
You
you,
too.
Your Honor.
At 10:06 a.m.
Court will note the appearance of Ms. Sachs on behalf of plaintiff. Matters before the court on the plaintiff's motion for genetic testing. Ms. Sachs, I note in reviewing your pleadings and say if there's no possibility that defendant is the biological father, then why wouldn't we not simply be able to test the plaintiff and Mr. Ferguson and determine again the paternity on that basis?
We would, Your Honor. Mr. Young has a right to establish paternity in the same way that Mr. Ferguson does, and so we included him for the purposes of completion. He would have the ability to motion this court anyways to get genetic testing, so
He hasn't filed that, so we'll wait until he files if in fact that's the case, and if we can get a determination without that, there's no reason, don't know if he's going to cooperate or what is going to happen. So what I'll do is the court will simply order that the plaintiff, Mr. Ferguson, the child will be tested at this particular point, and what happens is the court will make the plaintiff responsible for the cost of the testing. If in fact it should be necessary to have defendant tested, then the court would reallocate costs at that point. So you can prepare an order having the plaintiff, child, and Mr. Ferguson genetically tested.
Will do, Your Honor.
Okay, thank you.
We're also here on another motion for the same matter, Your Honor.
And
Custody, parenting time, child support.
Hold on, let me look and see if we have that.
that's, the genetic testing one is the only one that they provided to me, so.
What they have is a motion for genetic testing.
It was filed contemporaneous with the pleading, Your Honor, and it was renoticed when Mr. Young failed to be personally served. So it should be in the notice to appear for Antonio Young that he was supposed to appear on both motions this morning.
Well, you probably would doing all that. You probably confused the clerk's office and they didn't provide it to us. Is it in the notice? Up the notice.
Let's see. When did you renotice that? Let's see.
Oh my goodness.
I have June 3rd, a renotice a hearing on plaintiff's motion for genetic testing. Okay, so it looks like you filed 2 renotices on this with the same proof of service.
Correct, because one was for Antonio Young, who is the defendant in this matter, and one was for Anthony Ferguson, who's the interested third party, who's the biological father in this case.
And what happened is they didn't put the one renotice in because you renoticed like 2 of the same notices.
Well, what I'll do, Ms. Sachs, is obviously Mr. Young is not present, so he's not contesting. And obviously if he's not the bio dad, then there wouldn't be any basis for him to do that.
This is based on the biological child, Your Honor.
Yeah.
There's one biological child and one
Oh,
non-biological.
I'm the other child.
Correct.
Okay. Well, he's still not present. The court will grant your requested relief by default, being that he has not appeared. It is now 10:10 a.m. It was scheduled for 9:30 a.m. So you can submit that order under a 7-day notice.
All right, thank you, Your Honor.
Court will note the appearance of Mr. Todd on behalf of plaintiff, Ms. Greenlee-Clore on behalf of the defendant. This matter is before the court on the defendant's motion for custody and parenting time. Ms. Greenlee-Clore.
Thank you, Your Honor. In addition to what's in my motion, I'm just reiterating the parties are expecting another child in June, early July. They did just recently separate. My client is living in Mecosta, Michigan. He's living in a place where his father used to live. It's an extended trailer. Excuse me. He does have electricity, lights, all of that. The water, there is a situation with that at this time, but he does have a neighbor that is providing water to the trailer. So at this time, he is able to certainly provide everything a child age 2 should need. We're asking for the parenting time that's specified in the motion, Your Honor.
Okay, thank you. Mr. Todd?
Thank you, Your Honor. Your Honor, it's my understanding that since separation in April, the status quo of the parties is that the defendant has called approximately 1 time per week and has been coming down to visit every other weekend on Saturday for a few hours. we would request that this continue. This is very close to the Calhoun County parenting time for tender children between 0 and 12 months. And we believe that that would be the most appropriate remedy, given the fact that there is a child who's going to be within that 0 to 12 month timeframe moving forward. So we believe that is appropriate, especially given the fact that there is no running water. The defendant moved 2 hours away. He quit his job. His stability is unknown. The child has never stayed one night outside of the marital home, and the defendant has had no overnights alone with the child ever. So from a pragmatic standpoint, we believe it would be appropriate to put in place the 0 to 12 month provision for the tender years Calhoun County policy, which is in essence the status quo of what the parties have been doing. And then they can move forward from there on a temporary basis for the youngest child, moving through those various stages of the tender years. And we are amenable to giving the defendant credit for 93 overnights in the event that the court does choose that method.
Okay.
Your Honor, if I could address those concerns.
Yeah, go ahead.
Your Honor, again, these parties are recently separated. They were living with mother's parents. Now my client has moved back to his home where he's living on his father's land. So stating that he doesn't have a stable home, mother doesn't have a stable home, she's living with her parents. Additionally, I do want to note here that the only reason my client hasn't had parenting time is A, they were recently separated, and B, mother hasn't let him. The only thing she'll let him do is come and see the child. And he's made that drive every other weekend to see the child. And, excuse me, and hopefully when his second child is born, he'll be doing the same thing. But at this point in time, sorry, his parties were cohabitating up until mid-April and both taking care of this minor child. And he wants to have that parenting time of alternate weekends at a minimum. He is fully employed. He's working full-time at a dairy farm at this time. He's setting up his life again. After their separation, and he's preparing to have another child on the way. There's no reason at this point in time to deny him at least the standard parenting time for a child age of 2 of alternate weekends. And then when the new child is born, we can certainly go to mediation and work on a parenting time for what parenting time with that child will look like. But at this time, we're requesting alternate weekends minimum, Your Honor.
Okay. Mr. Todd, what's your response to the fact that the child's 2 years old?
Your Honor, I believe a place where the defendant allegedly very recently moved that does not have running water is not an appropriate location for a 2-year-old. And in addition, it was his choice. He quit his job, left the home, and moved 2 hours away. In the event that the defendant, remained within the county or someplace close, I think that would be different. The child has never had any overnights away from the marital home, and the defendant did not equally participate in child rearing. It's our understanding he does not know how to feed the child. He has not bathed the child. He did not equally participate in child rearing, and he does not do so. But even in the event that the court were to have him do every other weekend, which we don't believe is appropriate, but that would be problematic once the new child was born, because then he would end up, trying to come down and facilitating a little bit of parenting time, and it simply wouldn't work. And so that's why we believe the most appropriate remedy is to keep the status quo in place and use the 0 to 12 month provision within the county policy.
Okay. Well, in this particular case, I understand what you're asking, Mr. Todd, but again, this first child is not 0 to 12 months. So that's not really applicable in this particular matter. The court is going to grant the standard alternating weekend parenting time, alternating holidays as well. I'm not going to order any extended parenting time during the summer at this particular time. And we'll address that later. When the other child is born, we'll have to address as it relates to that particular child as well. So, and that you can calculate support based upon the 93 overnights, although it would not actually be applicable because there isn't the extended in the summer, but we can do it at this particular time because we may move to that after a hearing in this matter. I'll ask Ms. Greenlee-Clory that you would prepare that order and submit under 7 day.
Your Honor, for the parenting time, will it go from 6 p.m. on Friday until 6 p.m. on Sunday?
Yes.
And who provides transportation?
Your client, he's the one that moved. He can provide the transportation.
Okay, thank you, Your Honor.
Okay, thank you. Have a good day.
Thank
Court
you.
will note the appearance of Mr. Todd on behalf of the plaintiff. This matter is before the court on the plaintiff's motion to sell real property and other relief. Court has reviewed the judgment as well as your motion. And Mr. Blakely has apparently not appeared. It is now 10:20 a.m. It was set for 10 o'clock a.m. The court will allow you, Mr. Todd, that you can list and sell the property without the defendant's signature in this particular matter. The court would, in fact, order that out of the proceeds that the medical expenses would be paid in this particular matter. The court will allow you, Mr. Todd, attorney fees for having to bring this matter. Do you know what those are?
Your Honor, I apologize. I would need to calculate that, but if I could include that within the 7 day order.
You can include that and then make a statement as to what those are as well, and then include it in the order. And then after the payment of the medical, the attorney fees, then the balance, of course, the medical and the attorney fees would come out of the defendant's portion, and then the balance would be divided equally in this matter. Is the defendant still in the home?
Your Honor, defendant's exact whereabouts are unknown.
What?
Defendant's exact whereabouts are unknown.
Okay. What the court would do is I'd add in there that the defendant would be out of the home within 14 days of today's date. That way, you don't have any issues if he should come back or whatever. That way your client would have possession that she can do what she needs to do to prepare the house and get it ready for sale.
Absolutely, Your Honor.
Okay? You can submit that under 7 days.
Thank you, Your Honor.
Okay, thank you.
2024 at 10:30 a.m.
Court will note, this matter is before the court on the defendant's motion to set aside referee recommendation. Ms. Keach Welcher, it's my understanding that you, based upon your pleadings, that, well, I guess that the plaintiff had requested a transcript in this particular matter. Were you aware of that?
No, I was not.
Okay. Well, when that's requested, I'm not going to proceed with your motion because I want to see what the referee ruled, because otherwise I'm just kind of guessing at what the referee ruled about. So what I'll do is I'll simply reserve on your motion until the court's had a chance to review the transcript.
Sir.
Yes.
That transcript's not for this case.
Oh, that was a different transcript that was requested?
Yes, sir.
Okay, sorry. I saw that there was a transcript request back on May 29th, so I assumed that it was for this.
No, I requested a transcript for our last court hearing for a different case in Eaton County.
Okay, then. Well, what I'll do, Ms. Keach Welcher, in this matter is I'm still going to want a transcript, so I'm going to leave it up to you to order a transcript and provide the transcript to the plaintiff and to the court. And then what I'll do is allow you to renotice your motion after we've had a chance to review the transcript.
Is that for her?
Yes, because she was the one that filed to set it aside.
Okay. Can I say a couple things here?
No, because until we get the transcript, whatever you're going to say is not really.
Well, this is the fourth time we've been to court for child support, sir.
Well,
and the transcript's it's only the last motion that all three of us was in, so it's the same thing.
Well,
I'm losing out. This is the fourth time I've had to lose out on work.
Okay. She has a right to file an objection, and if she does, the court has to hear that. But I can't hear the objection until I see the transcript to see what she, and then she's going to have to establish either that the referee made a factual or a legal error. But I'm going to have to see the transcript first, so I can't guess at what they're going to say. I guess that's what I'm saying. I have to wait and see.
What?
So
I guess I don't. The transcript for what? Is what
from the referee hearing.
It was you.
Okay.
You're the one that did it last time.
She objected to the referee order in this matter, not to any order I did. She objected to the referee order.
Yes, sir, I did.
I can't make a decision on what the referee did if I don't have a transcript telling me what he did.
Okay, I got you.
So as soon as I get the transcript, I can review that. She can renotice the motion, and then I'll be able to determine whether there's any legal or factual issue that the court needs to decide.
Okay.
Okay?
So is that still going to postpone her paying child support then?
No, the order remains in effect until such time as it's changed.
So it starts when? Because
whatever the date that was in that order, probably it was either the date of the notice of the motion or the date of the hearing. I don't have the order right in front of me today, but it'll tell you where it says what the amount she pays. It'll say at the side on the right, it'll say when it's effective. And then effective date is the date that she has to pay.
All right.
It's this month. And can I speak for just a second?
No,
I don't understand.
I want to get a transcript, ma'am. All of this stuff.
That's what I'm saying. I don't understand what I have to do to get a transcript. What do I have to do?
You'll have to go to the clerk's office and you fill out a form requesting a transcript of that referee hearing.
Okay.
That will tell me what the referee considered for purposes of this.
That's all I had. I just didn't know what to do.
Okay.
Thank you.
Do that, and once the transcript has been provided, then you can renotice the motion, because then I'll be able to review the transcript.
Okay.
Okay.
Thank you very much.
Thank you. Have a good day.
You too.
6 a.m.
Court will note in this matter that's before the court for three motions. The plaintiff's motion to join Mr. Lee as a defendant for an extension to file a revocation of paternity and to determine a child born out of wedlock. In this matter, the defendant has not appeared, so he's not objecting to that. Mr. Lee, are you objecting in any way to being joined in this matter?
No, sir.
Okay. I guess I'll ask Ms. Bartson, have you had any DNA testing done?
Yes, I turned in two DNA tests. One was for Mr. Willerick, and that was a legal test, and it determined he was not the father. And then I did do one with Jason, but that one was not a legal test, and it determined that he is the father.
Okay. Well, what we'll do is, because of that, when we have to take some testimony in these matters from all the parties, we don't do that on a Monday because we don't have time to do that with all the motions that we have. What we're going to have to do is, Ms. Bartson, you have to contact my office and set up for a Wednesday. We'll do it a Wednesday at 1:30. That's when we do those. And we'll take some testimony. It won't take long. It'll probably take about 15 minutes. And then we'll be able to make the determination based upon, you're going to have to file the DNA. I didn't see any in the file when I was looking. If you filed it, did you file that with the clerk?
I did.
Okay. We'll look and we'll try to find it. It wasn't with the paperwork that I received. So we'll try to, if it's filed, we'll try to pull that up and see. You don't need to file if it's there.
I can bring in another copy as well.
Well, we have an order for joinder, order for genetic testing, and order determining child born out of wedlock, and an order regarding revocation of paternity.
Just give me the one for joinder and the others will hold. Okay, we will, again, contact my office and we'll set up for a Wednesday hearing when Mr. Lee is available, and we'll proceed that way. We'll have to notify Mr. Willrich, but he may not show. I don't know.
Okay.
So that's all we can do today. So you're free to go. Have a good day.
Thank you, sir. You have a good day too.
Thank you.
King versus Elizabeth King. Attorney Moss is filling in for Attorney Redmond for the defendant.
Okay. Good afternoon to both of you. Mr. King, I'll let you know this is a scheduling conference, and a scheduling conference is whereby the court puts in place various procedures and dates and stuff so that we can have the case proceed in an orderly fashion. So what happens, I'll go to you first, and then I'll go to Ms. Moss. In this particular matter, what issues do you believe are in dispute in your case, sir?
Parenting time.
Excuse me? I didn't hear you.
Okay. Parenting time.
Parenting time?
Yeah.
Okay.
Also, I got a letter from her attorney about anger management and parenting, but I don't really have anger issues or anger problems. And I honestly think she needs parenting time more than, parenting classes more than I do.
Okay.
Because I took care of the kids better than she kind of did.
Okay. Just a moment. I'm having some computer issues. Ms. Moss, what do you believe the issues in dispute are?
Good afternoon, Your Honor. I agree that parenting time is at issue. So legal and physical custody are at issue. There's some personal property at issue. I believe the parties own a mobile home together, but not the land that it's on.
Okay. Is that correct, sir? You do have mobile home?
Yes, we both own the mobile home. But I paid for it, and I paid monthly on it, the lot rent.
Okay. Well, regardless if it was purchased during the marriage, it's a marital asset, so the court has to address that. Are you engaged in any discovery, Ms. Moss? Have you done that?
Your Honor, at this point, we have received plaintiff's financial disclosure form, and ours will be submitted It's been completed, but because of transportation issues, it's being mailed and will be provided to plaintiff.
Okay.
I do think we'll need to do some additional discovery. If we could have that ordered, I'd request 90 days.
I'll give you till July 1, and you don't have that much time, but you'll just have to expedite it a little bit.
Okay, thank you.
Sir, what that means is that you have until July 1 to acquire information from the other side. So if there's anything that you need in the way of discovery, you're going to have to do that before July 1. Do you understand that?
Yes.
Okay. So whether it's interrogatories, requests for production of documents, depositions, et cetera, you're going to have to do all of those discovery things before July 1. So I would tell you to start working on that right away, because the time does go fast, and you don't want to get caught without doing any of that if you anticipated any. Court will set July as the mediation month. Mr. King, do you have anyone that you recommend, an attorney mediator that could handle the case or not?
I don't know anybody.
Okay. Ms. Moss, who would you recommend for a mediator?
Is Mr. Brundage still accepting cases?
Yes, he is.
That's who I would request.
Mr. King, just so you're aware, Mr. Brundage does handle about, probably 85 to 90% of all the mediation in the county. So, and if he's not available or can't, who would you recommend as an alternate?
Attorney Podolsky.
Okay. Do you have any problem with Ms. Podolsky serving as an alternate, Mr. King?
No.
Okay.
But I have a question.
Sure.
What am I supposed to do before July 1st?
All your discovery. Discovery is the process whereby you acquire information from the other side. And that has to be done before July 1. The court will set August 5th, 2024 at 1:30 p.m. as the settlement conference date. Parties are required to be present unless we've come to a full resolution prior to that time. Mr. King, so you know, all of this stuff that we've been talking about will be in a case scheduling order. You should get that at the end of the week or at the latest beginning of next week. Make sure that you pay attention to the particular dates and times in there, because there's things that you have to do in a given time frame. If you don't, it could have an adverse effect upon your case. Okay, sir?
Okay. Also, one more question.
Yep.
Am I able to see my kids at all? Because I haven't seen them since she left, and it's been 2 months.
If you are not, you have a right to file a motion for parenting time. You'll have to file that motion, and that can be heard any Monday morning, either at 9 o'clock, 9:30, 10, or 10:30.
How do I file for motion for parenting time?
Go to the circuit court clerk's office and get a improper motion. You fill that out as to, again, basically the basis for your motion, both factual and legal basis, and then your requested relief. You then file it with a notice of hearing, and you serve Ms. Redmond in this matter and have it heard on a particular Monday. You can pick the Monday. It's just whenever you have to give the other side at least 9 days notice by mail.
Okay. By mail.
Okay.
Okay.
Anything else, Mr. King?
No, sir.
Ms. Moss?
No, Your Honor.
Okay. Thank you. You're free to go. Have a good day.
Thank you.
So
my thing is why wouldn't she in court?
For the plaintiff, Attorney Stewart for the first defendant, Orbit Marketing, and Attorney Olderman is the receiver.
Okay. Good afternoon, gentlemen.
Good afternoon.
This is the time, place set for status conference. I do note that Orbit Marketing had filed for bankruptcy. Mr. Zosmer, fill me in on what's happening besides that.
Are you there, Mr. Zosmer? Hello?
I'm sorry?
Mr. Zosmer, I stated that Orbit Marketing had filed for bankruptcy. I said, otherwise, bring me up to speed. What's happening in the case?
Okay. Your Honor, as you're undoubtedly aware, as soon as Orbit Marketing filed for protection under Chapter 11, it received the benefit of the automatic stay, which prohibits the receiver from moving forward with his duties and obligations. Debtors Counsel and I have reached a resolution to terminate the automatic stay so that the receiver can proceed. As required by local bankruptcy court rule, I had to give 14 days notice to all creditors of that. We are still in the notice stage. That notice period expires this coming Thursday. Assuming there is no objection to the proposed termination of the automatic stay, the bankruptcy court should enter an order to that effect, and Mr. Polderman can move forward as if the bankruptcy was never filed.
Okay.
As to the individual defendant, Mr. Thompson, he has not filed bankruptcy. There is a judgment entered against him as well. The credit union sort of got sidetracked due to Orbit's bankruptcy, and we haven't focused on Mr. Thompson, but that may be coming.
Okay. Mr. Stewart, enlighten me. What's happening with regard to your client?
Your Honor, as Mr. Zalzmer stated, Orbit Marketing did file bankruptcy. There was a different bankruptcy attorney. I think when Mr. Zalzmer says, Attorney Zalzmer has said he's dealt with debtor's attorney, I think he means the bankruptcy attorney, Jim Oppenheiser.
That's correct.
Yeah. And so that is my understanding. My understanding also is that Mr. Thompson has spoken with Mr. Polderman a few times and has been working with him a little bit as to the receivership. But at this point, I'm kind of leaving it in the bankruptcy attorney's hands, so I don't have a ton more information, Your Honor.
Okay. Well, what are we doing with regard to Mr. Thompson at this point? Anybody know?
They have a judgment. I believe he's trying to work with them to help them with selling the property and maintaining the property. So,
okay, so there is a judgment then?
I believe Mr. Zalzmer, a judgment was entered, right, when there was the default earlier?
Yes, Your Honor, you entered a judgment against all defendants.
Okay. Well, that makes it easy enough.
Yeah.
What, well, you have a few days left as it relates to the bankruptcy matter. When do we anticipate that we would know anything on this, that we might be able to get back together to wrap things up?
Your Honor, may I suggest that we wait some period of time to do that, because once the stay gets lifted, Mr. Polderman, the receiver, is going to, need some time to proceed with marketing, selling, whatever else he has in mind. So I'm not sure that we could give you a comprehensive update for 90 days or so.
Let me do this.
What do you think, John?
Let me do this. I'm going to set it out about 60 days so that we can check in at that point and see where we're at. And I don't want to put it out too far. So we'll put it out about 60 days and then have you back, and then we can find out where you're at and what needs to be done at that time.
Thank you, Your Honor.
Okay. Well, we'll let you go today, and we'll send you a new notice and see you back in a couple months.
And Your Honor, if I may quickly, on a side note, I have a habit of watching YouTube videos of crazy court moments, and one of yours was on there, and you demonstrated incredible patience and judicial composure. I wanted to compliment you on that. There was a custody/child support issue that looked, wow. The patience you have to be a judge.
I'll have to relate that to my wife, that I showed extreme patience. She won't believe it, but I'll relate it anyway.
Thank you, Your Honor.
Okay.
Have a good afternoon.
Thank you.
Thank you.
Thank you.
Defendant is not here. Let's continue.
Ms. Sachs, I know we were in this morning. What's happening now? Is anything that you're aware of?
I mean, we have not mediated this case, Your Honor, because we've had no facts to go on in order to mediate. I'm not aware of any reason that defendant is or isn't here. He did not contact me saying that he was in any position to not arrive, but I did not contact him to make sure he was arriving either. So
yeah. When, in the case scheduling order, when did we set it for, mediation?
It was supposed to be completed in the month of May, Your Honor.
Okay, well, we've missed that, obviously. Why don't we set it, now, who was gonna mediate this?
Brundage, Your Honor.
Why don't you set it up for, July, sometime in July, send notice out to the other side as to when that mediation is, and then we'll see what he does. If not, we may end up having to default it.
Okay, I mean, I would ask that we default him today for failure to appear at the settlement conference, as he was specifically warned in the notice to appear, but.
I know. We'll set it to give him another I don't know if maybe today, this morning with the hearings, that he thought he was doing what he needed to do. I don't know. But we'll set it for mediation, send the notice out, and we'll see what he does at that particular point.
All right, so Attorney Brundage, sometime in July is acceptable, Your Honor?
Yes, yep, anytime in July. And then what we'll do is we'll then set a settlement conference on August 5th at 1:30 p.m.
Do we have to redo the case scheduling order? Okay.
Nope, that's all we need today then. You're free to go. Have a good afternoon.
Thank you, Judge, you as well.
1:46 p.m. Attorney McIntyre for the defendant.
Okay, good afternoon to both of you.
Good afternoon, Your Honor.
Ms. Whitby, I'll go to you first because you're the plaintiff. And the scheduling conference is whereby we attempt to put in place, again, some procedures and some dates on which things will occur so that the case proceeds in an orderly fashion. So I'll ask you first, ma'am, what do you believe to be the disputes in your case? What are you fighting about?
There's not a lot we're really fighting about. We've been getting along actually pretty good. So just kind of get along in the marriage. So
okay, well, I'll go to Ms. McIntyre, then maybe she can light me more. Ms. McIntyre, what's happening? What issues do you believe to be in dispute in the case?
Your Honor, I believe that the parties are getting along fairly well. My client agrees with the number of overnights that he's exercising now. I think we need to just tune up the schedule a little bit.
Okay, and how do you suggest we do that?
Well, I would like to be able to, and I've offered this to my client, to have the three of us maybe either on Zoom or in my office sit down and try and hammer out a schedule that works for both.
Okay. Why don't I do this is we'll give you an additional 30 days. We'll reset this in 30 days. If you don't have an agreement within that time, then we'll have it proceed as a contested matter.
That sounds good. And Your Honor, I did not get notice of today, so I'm just curious where that may have been sent.
I have no idea.
Okay.
Yeah, I'll have to have them look in the file and see.
Okay, thank you.
Ms. Whitby, what we're doing is we're going to give you that opportunity to try to come to a resolution. If you don't, then I'll go down as contested. I didn't want to do it now because if there's a chance that you can resolve it, part of the scheduling would have been putting the matter into a mediation process, and there's a cost associated with that. If you can agree, I don't want you to incur that cost, even initiating the mediation. So we'll give you that additional 30 days to meet with Ms. McIntyre and see if you can come to an agreement. If not, then we can always proceed that way in about 30 days.
Okay.
Okay.
And Ms. Whitby, if I'm going to reach out to try and get your email address. So
okay.
Keep an eye out for an email.
And okay. Attorney McIntyre, is your email still michelle@mcintyreLawOffices.com?
No, that's why.
Oh, so what is the email now?
Yeah, it's michelle@mcintyreLawPC.com.
Okay, so you're complicating it by giving us a few more letters. Is that it?
It was a whole disaster, so I had to switch my email address.
Okay.
Okay, I got it right now. Thank you.
Okay.
Thank you.
Okay, thank you, and have a good day.
Thank you.
You too.
You too.
M.
Bye-bye.
Attorney Schaefer for the plaintiff and Attorney Henderson for the defendant.
Okay, good afternoon to everyone.
Hi, Judge.
Good. This is a time place set for settlement conference. So you went to mediation, that was not successful. And so I guess I'll ask, just so we know, is we're set up for trial. How many days are we going to need and what issues remain in dispute?
I think it has been resolved, Your Honor. We have bombarded each other with enough emails to paper a wall. And I believe that we have come to a resolution.
Okay. Do you want to recite it, put it on the record now?
I do not. I think we got probably some verbiage that needs to be ironed out, but if Your Honor wants to set this for trial down the line, fine, as a buffer, but I'm reporting that I believe that it's going to be resolved.
Okay. Ms. Henderson, is that your thought?
Yes, Your Honor, and I would not have opposed to presenting the proofs today if Mr. Schaefer is prepared so we can preserve those.
Okay. Do you want to do that, Mr. Schaefer?
No, I want to wait till we get the whole thing done.
Okay. Why don't we do this is we'll set up for another conference about 30 days and see if you haven't, hopefully you've got everything done at that point, or if not, we'll set it for trial.
Okay, very good.
Okay, thank you.
Thank you.
All right, we'll close the record here.